Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. I have a great topic for you today. I am going to be talking about getting permanent residence through a green card holder spouse. Yes, that's possible, and I want to tell you the ways that that's possible. Hi there, Nat. It's nice to see you. Thanks for the greeting. So that is absolutely possible. As a matter of fact, right now is a good time to apply because there are no wait times. That can change at any time because it's spouses of permanent residents. They usually go on a wait list because so many people are applying. Usually applied that there were more people applying than were more people than available immigrant visa numbers, because under this category, as the spouse of a permanent resident, you have to have an immigrant visa number available to you to be able to move forward in the process. However, right now there are more immigrant visa numbers available than there are applicants. And because of that, spouses of permanent residents are not on this wait list, and they're able to be on the same timeline as spouses of US citizens. So you should definitely consider pursuing that option through your permanent resident spouse. But here's where it may not be a losing situation. If you even apply through your US permanent resident spouse, and your permanent resident spouse then becomes a US citizen, you can upgrade from the spouse of a permanent resident to the spouse of a US citizen. And that means that you would still be on a fast track. So in the meantime, you may be able to apply through your permanent resident spouse, and then once they become a citizen, you'd be able to move forward through your citizen spouse. So applying through your permanent resident spouse is not going to take that opportunity away from you should they become citizens. Now, of course, keep in mind this is general information and it's not personal legal advice. So whether you should move forward with a process like that is going to be dependent on what your particular circumstances are. Now, here's a very sticky situation that I see spouses of permanent residents going through. And that's where they're here in the United States, the immigrant spouse of the permanent resident, and they have overstayed. Maybe they got married and they were already out of status, or sometimes they don't realize that the option is available to do adjustment of status and they go ahead and overstay without applying. In that case, where you've overstayed the time that you were allowed, you're not able to do adjustment of status again through your permanent resident spouse. So, my advice is if you are here visiting on a visa and you're considering moving forward with adjustment of status or staying, don't make that time go by. Don't overstay and then figure out your options. Go ahead way before your time expires. Go ahead and see what options are available to you to stay in compliance with your visa, stay in compliance with your status, and to still get permanent residence, because that option could very well be available. But once you've overstayed, it's not that you don't have options, but your options become much more limited. For instance, when you're the spouse of a permanent resident and you're out of status, you have to either wait for your spouse to become a citizen before you can apply for permanent residence through adjustment of status, that's staying in the US and getting your permanent residence, or you have to go through what's called an I-601A waiver process. Through that I-601A waiver, you'll have to then prove that your US permanent resident spouse will experience extreme hardship if you don't get the permanent resident. So, and this is a type of discretionary waiver. It's not guaranteed to be approved. And even though some individuals, they only have that option, if you can avoid the extra complications of that option, why not do that? So keep in mind that before you do anything, before you stay over your time, before you file any documentation, this is where it's so important to make sure that you schedule a consultation. This is what I'm here for. I'm here to assist individuals, assist clients with their process going forward, with the best process for them based on their circumstances. And sometimes the best way to make sure you start out on the right foot is to go ahead and take action after you get representation and after you know the full implications and consequences of your actions going forward. So that is about it in regards to being married to a permanent resident spouse. It's different from being married to a US citizen spouse. US citizen, being the spouse of a US citizen, means that you can go ahead and apply for adjustment of status, stay in the United States, and still apply for permanent residence, even if you're out of status. But keep in mind this, that if you are the spouse of a citizen and you cross the border without permission, you weren't paroled or admitted into the United States, then that could also mean that you're not eligible to apply for adjustment of status. You have to meet one of those requirements where you were inspected, admitted, or paroled into the country. Parole means that at some point in the process, maybe you came in and then the immigration officers or the border patrol provided you some sort of permission to stay here for a period of time. It's not official status, but it sort of puts you in a position where they're giving you some time to be here and they're not going to expel you from the country during that time. So it's not necessarily, you don't necessarily have to show that you entered with a visa, but there are other options as well to show if you were paroled. Sometimes that could be issued by a judge. Sometimes that could be issued by the patrol, by the border patrol, the officers at the border. They do have that discretion to provide parole under certain circumstances. If you can show that, that may very well allow you to do adjustment of status as well. So keep that one in mind. But if you're the spouse of a citizen and you don't have any of those to show, then you are also going to have to pursue the I-601A waiver, where you're going to have to get a waiver, get permission to get forgiveness for coming and staying or crossing the border without permission and then staying. And that would allow you to attend the final interview at the embassy in your home country, where it will not be held against you and where then you would get approval. The thing with this I-601A waiver is that that has to be your only immigration violation. If you have other issues going on, like misrepresentation or fraud or past criminal offenses on your record, or anything else that may render you inadmissible, then this I-601, unfortunately, I-601A waiver would not work. Now, the I-601A waiver doesn't allow you to stay for the entire process in the United States, but it allows you to stay in the US for most of it, to wait for them to schedule the interview at the embassy after the waiver has been approved. And at that time, you would fly out or cross the border to go attend the interview and to be able to prepare for the interview, and then come back into the country with an immigrant visa to become a permanent resident. So that's what the I-601A waiver is. And some people don't have the option but to pursue that waiver to be able to get status here. All right. So I've said my piece. Now I'm going to leave it up to you to ask your questions, or go ahead and schedule the consultation. If you want to get personalized legal advice, go ahead and go to the link and then schedule your consultation so we can talk. In the meantime, go ahead, put any question, any immigration questions you want in the comments, and I will answer. So I see here on YouTube, hi there, so nice to see you. My PD is in July 2022. When to expect to be approved? I badly missing my wife. So I'm sorry for the separation. You know, in the case, so you said your priority date is July 2022. Um, in the case that you're outside of the country, and it does sound like you're outside of the country because you're saying you're missing your spouse, what that means is you have about an 18-month to 24-month process. Unfortunately, that's the average time that I tell my clients to prepare for. And I really want to prepare my clients for this. I don't want them to have expectations that are not realistic. And so that's why when it comes to, we can hope for the best because as attorneys, we don't have control over processing times. That's important for you to know. But we can only do the work and pray that they have cleared the backlog or that your case will fall within one of those freakishly fast processing times. But to be realistic, you're looking at about an 18-month to 24-month process from the time you started the application to the time that your interview is scheduled. Um, and if you don't, another thing to be careful about is at the National Visa Center. If you're not doing it correctly, you can face additional delays. I often say this: one mistake at the National Visa Center is a 3 month delay, right? So the National Visa Center, it works with the embassy outside of the US to arrange for the interview. So what the National Visa Center does is they collect the documentation, process the applications and the affidavit of support, and then they determine whether it's all good. Once it's all good, you get a notice that you're documentarily qualified. However, if it's not good, you're going to get notification that you need to fix this. They'll indicate what they're not accepting or what they've rejected. That leads to the delay, and that can be 2 to 3 months right now. Hopefully, that will improve, but that's what's happening. So at that point, we're very careful with our clients' applications, especially at the National Visa Center, to avoid such delays because it can, in addition to the 18 to 24-month process, it can be so frustrating to have an additional 3 months added on to those processing times. All right. Hi there, good day. My niece is now 21. How long will her naturalization process take if she gets started now? So, for my clients, I'm seeing anywhere from 2 months to 6 months to get citizenship. But that doesn't mean, keep in mind, that I am basing my estimate on my experience and observations, but it does not mean that I control the processing times. But I do have many clients that go through the process, so I'm able to observe the average processing times. Now, once again, whenever there are errors in the applications or extra questions that come up, individuals can see longer processing times, but I am seeing for my clients, I'm seeing anywhere from 2 months to 6 months. What if I cannot prove my husband and I was living together due to the fact that he kept everything from me? So, that indicates a serious problem. And, you know, um, it usually comes up in cases where we're applying for spouses that of US citizens who have been mistreated by the US citizen or legal permanent resident. And so the way that we approach this is different from if you were living with a spouse, if you're actually filing with a spouse. And this is called VAWA. So in the VAWA cases, we look at other types of evidence to be able to show proof of residence, and it can be witness statements. It can be other things like shared address to show that there was mail going to the same address. And then we also brainstorm. So this is not the remember, none of this is a one size fits all. And doing these cases is hard work, and it takes a lot of thinking and brainstorming. That's what I also do with my clients. We consult with each other, and I typically know what direction to go in and what creative ways to be able to prove residence with the spouse where that's necessary in the VAWA cases, or any case where you need to prove that you were residing with your spouse. Because remember, any credible evidence is going to be accepted. Whether it's credible, though, that's where preparation is key to make sure that it's credible. Now, when we're talking about applying with your spouse and they're keeping everything from you and they're leaving it to you to manage the paperwork, but yet they're not really fully cooperating with you, that's a problem. And usually, what happens is, and marriage like that goes from filing, based on my experience and observations, it goes from the spouses filing together to then I come in and I start to represent the immigrant spouse who is, usually at the disadvantage here in a VAWA situation, because this is a red flag that something is going on in the marriage. If this spouse is keeping things from you, they're not cooperating with you throughout the marriage-based process, that's a problem. And it usually, to me, when I spot that, there's you, and I ask about it, it usually opens up a can of worms to all sorts of mistreatment that's happening in the marriage. So if that's the case, there's a problem. What I when I do talk to couples who I end up representing, I do look at these couples to determine whether they have a high chance of success. And I usually can tell from the get-go that they are going to be successful. Because yes, I am the attorney and I work to the best of my ability to make sure that we present a great case for my clients. But at the end of the day, what if they're not cooperating with each other or me as the attorney, then it's not going to work. And so, in cases where the couples are not working together, that's where I usually see everything go downhill and the marriage based process implode in their faces. So it really, the number one predictor of success is how involved is the couple, how involved are the two people in that relationship together. Would it be best to marry and adjust your status in the United States? Whether it's best for you is going to come down to your particular circumstances. That's where the consultation is going to be very important, and to get representation through your process. What I would say is, and for example, I have consulted with couples who they've gone the consular processing route instead of adjusting status, meaning one spouse is outside of the US, because the immigrant spouse, they have maybe a career, they have a business, they have things, loose ends to tie up in the country, and they really need that additional time, the processing time outside of the country to do those things. And so they're fine with staying outside of the United States. But then you have the spouses that they are willing to give up their lives in the country and stay in the United States to complete the process. So it really is a whole conversation filled with follow-up questions from me to you to determine what could be best for you. So go ahead, schedule that consultation so we can talk. Um, How long will it take after my niece naturalization for her mom to get a green card? So it depends if her mom is outside of the US, estimated 18 to 24 months right now. That could change. Hopefully they improve processing times. However, if she's in the US, you're looking at about 6 to 12 months. Can a US citizen file for their mother and mother's husband who is not the citizen's father? All right, so let's read that again. Can a US citizen file for their mother and the mother's husband who is not the citizen's father? Great question. Okay, so the citizen can definitely file for the mother. But the citizen, whether or not that citizen can file for the stepfather, is going to be dependent on whether the mother and the husband married before that US citizen turned 18 years old. If that's the case, then under immigration law, that husband is the stepfather, qualifies as the stepfather under immigration law. And that means that she would be able to sponsor the stepfather, but it would not be where they're all on one filing. Each petition is going to be different. However, if the mother did not marry the husband before the US citizen turned 18, then the mother would have to turn her own and sponsor the father after she becomes a permanent resident, because the US citizen um, child would not be able to do it in that case. Also, keep in mind that the citizen child has to be age 21 and up to be able to sponsor any parent. All right, great questions. So I'm on YouTube, I'm on Instagram. So don't hesitate to put your questions in the comments. I'm here to answer your questions today. I was talking previously. If you missed it, you can always go back to watch the saved live, because I do save them and I do post them right after. So go ahead and watch them about the topic, but it's getting permanent residence to a green card holder spouse. I gave you the T on all of that. It's really up to you to decide whether you're going to do this consultation to get a detailed evaluation. Because remember, the information I'm giving you is not personalized legal advice, and it can go completely different based on anything that you've told me. Thanks for the follow. I appreciate it. How long is the National Benefit Center taking to process I-485 and I-130? So I've seen anywhere from 5 months to 5 months to a little over 12 months. And then keep in mind, processing times is really dependent on how good your application is, how complete is it. If there is anything missing, you could expect delays. You could expect some delays, so you have to be careful about that. When filing for VAWA, is it best to bring my child in the country when then add her or let her stay in a foreign country? Great question, but that is such a complicated question. You should really schedule a consultation at this point, because those kind of considerations come with consequences. And depending on what's going on, you want to make sure you get the best, most specific advice about a situation like that. So, whenever your questions are very detailed and complex, you should schedule a consultation. As a matter of fact, sometimes you may think you don't have a complex question when when it is in fact complicated, and there are a number of considerations. So always schedule a consultation and get representation. Don't go your process alone, because that's where I see a lot of unfortunate things happening. How much does a sponsor have to make to qualify for a household of five? So go ahead and look at the I-864P form on the USCIS website, and it's going to give you that information. Would you suggest a divorce if you've been married to a US citizen for a year and they keep withholding the documents to start filing paperwork? So I can't suggest a divorce, but what I would say is get legal advice, protect your interests, schedule a consultation. That is a basis for that could be a basis to qualify for VAWA. I have many clients who are in this situation and they have gone through to get VAWA. So go ahead, schedule a consultation, and let's talk about the situation. It's not necessary to be divorced to file this, to get this the status on your own, and it's confidential. It only involves you, and you don't have to depend on the spouse to be able to move forward. My uncle came here when he was 12 years old. He recently lost his document and he's having problems trying to get them. Can you give us advice? He can schedule a consultation and I can definitely advise there. Is it quicker to sponsor my stepdaughter, or would it be quicker to get a visitor's visa and then file for residency? So, what I would say is adjustment of status, being in the United States and applying for adjustment of status is a preferable option. But you have to determine whether that works for you and your family, because sometimes it does present some challenges as your relative is waiting in the US. And you also want to make sure that you, as a stepmother, you qualify. So, if you do qualify, now another thing is you can't go and get a visitor's visa for the purpose of filing for residency. The immigration can, if they determine that that's your intention, they can deny the visa right on the spot. And then they can also, if you enter the country with a visitor's visa and then file for residency, they can accuse you or charge you with misrepresentation or fraud. Because when you're going for a visitor's visa, the intention you should be having is that you are coming to visit the United States and no more. Not, you're not intending to live permanently. So you have to be careful about that. Um, that situation. And then, so if you're thinking, go get the visitor's visa to file for residency, for sure that visitor's visa would be denied. Um, okay, so let's see. You're welcome. Keep putting those questions in the comments. I'm on YouTube, I'm monitoring the comments, and I'm also on Instagram. So go ahead, put those questions. These are great questions. I really love these questions, and I think it helps me to answer questions that are more detailed, but that you should really know that they're good questions. But at the end of the day, what you need to do is make sure that you schedule a consultation. I can't stress enough how important it is to get legal advice and representation through your process, because a process that you think is simple is not, may not be simple, and that's where I see a lot of mistakes being made, and where I see a lot of errors, mistakes, delays because of that. The process, there's an underestimation of what's required. All right. So I don't see any more questions. Thanks so much again for your questions. Now, here's the deal. Here are some immigration updates that you should know about. So, the public charge rule has new public charge rule has gone into effect. That's where they want to make sure that you're capable of supporting yourself in the United States, or that your U.S. citizen or resident relative can do that. And so they have issued a policy manual that has detailed a number of factors in determining whether someone is a public charge. They have also issued a proposal to increase fees. And so tomorrow I'm going to be talking about those two. So I'm going to be talking about at least one or of two of those issues. and then the next day I'll talk about another one because they're so complex. So we'll go ahead and touch on those topics so you know about them. But now I believe that the earliest that these fees will increase is March 2023. So now is the time to get ready and prep yourselves to explore your options and then to get started right away. Hi, Lulu. The consultation fee is for $150 for up to an hour. It's a really detailed consultation. It's worth your time and money. Once you become my client, I don't do hourly rates. My fees are flat fee rates. However, the cost of the fee is going to be dependent on what your case is and what will be involved. All right. So I see one more. Would there be an RFE after prima facie determination? Yes, there could be a request for evidence even after that. The prima facie is saying, hey, based on our initial review, we think you qualify. But then if they do a more detailed analysis and they have more questions, they'll definitely issue an RFE. I did an I-130. How can I add his family? No, he was single that time. Now he has a family. So usually at the National Visa Center stage, there is the opportunity to add qualifying family members there as well. All right. Thanks everyone for your time and all your great questions. I'll be back tomorrow. We'll talk about fee increases and then also the new public charge rule because they've updated the adjustment of status application to ask for more detailed questions about your about any possible public charge issues. So you want to be aware of that. All right. Have a good one. Bye bye.